Adarsh, thank you so much for joining on HW News. And
thank you for having me.
So this particular development in the case where the Karnataka High Court today said that you are not the direct aggrieved, do you see this development as a setback for yourself?
Certainly not, because this is a long-drawn process of the judicial system. And we are very happy that the case is still on, because the next hearing is on 22nd, where the objections are to be filed by us, and then it will be heard in detail later. So in the first place, an interim stay is not exactly a quashing of the entire process. It is just an interim stay. And we are hopeful that it will not be quashed and it will be allowed to go further. I'm not able to hear you.
What I'm saying is that now we'll go one by one as to what happened in the court. You must have also been present, and your lawyer was Prashant Bhushan. So, of course, the arguments must have been very interesting. Now, what I'm reading on all the law websites, Live Law, Bar Bench, and everywhere, the Justice Nagaprasanna had ordered that permitting investigation, even prima facie till the statement of objection are filed by respondent, will be abuse of process of law, and in that light, I deem it appropriate to interdict further investigation in the matter till next date of hearing. That is the first submission by Mr. Justice Nagaprasanna. After that, what he says is that it is only then prima facie extortion can be established against the accused. It is a well-settled principle that criminal law can be set in motion by anyone. But there are provisions in IPC that they can be set in motion by only aggrieved. It is not his, that is the complainant's case, that he's put under fear, and the complainant in the case at hand wants to project section 383 of the IPC. He is an aggrieved party, which he is not. Now, Adarsh, do you see this as a challenge, because you need to establish that you are somewhere directly aggrieved with the case? So what is the kind of arguments and submissions which you and your lawyer will be putting forth now when the court meets on 22nd?
Well, in fact, to the said argument, or the the statement in the order, our advocate Prashant Bhushan ji clearly argued and vehemently argued that as per the Ayer until case, a constitution bench of Supreme Court has clearly given has clearly held that any person can move the court of law as per the criminal jurisprudence, because these are almost his words. I'm not exactly paraphrasing. I'm just telling you the gist of the thing, what he said in the court. And he also said that in case of a murder, it's also personal. One person will be murdered, but again, it is a crime against society. So it is actually a criminal case. That's the reason why anybody can file a 302. And in the same way, so many other cases. But there might be some express provisions which prohibit a certain offense to be filed against somebody. For example, it's defamation or a perjury, where only the court of law can move the case in case of perjury. Whereas in all the other cases, until unless there is an express provision in the statutes, until then nobody is barred from moving the court of law as far as the criminal law is concerned. So that was his submission. And the second submission, which is very important here, is since the court questioned whether the aggrieved, here it means the persons who are extorted, only they must be before this court of law. For this, our advocate Prashant ji said that obviously they are actually not just the aggrieved, they are also the beneficiaries. Because in what way? Because of extortion money being donated through whatever means, here in this case electoral bond, then they get a relief from the fear of more threats or other coercive actions. So they are saved from those coercive actions in the future. So they are the beneficiaries, and so such beneficiaries will never come to the court of law to allege that there is a offense being committed against them. So with all this in picture, I think we are in good hands. Though we can say that this interim stay is a minor setback because there are different judgments and different citations which will be presented in the next date, which is not very far off. Like it is 22nd of October, which is
Right.
hardly a few weeks. So we are very hopeful, and we will fight it till the end.
Adarsh, will you see this then as a win-win for both sides? Your side as well as Nirmala Sitharaman, Nalin Katil, B.Y. Vijayendra, all these leaders now will have a breather and they can also reply back. So would you see this as a win-win for both sides? And will this become a challenge for you then in the coming days?
Well, actually, once we have taken such a big case, it is always a challenge. There is no backing off from that challenge. And whether it's a win-win or a win-lose, we don't win or lose here. The opposite parties might be thinking about winning or losing, but for us, it is a public interest case. So it is not a personal case. So anybody, if we win, the public wins. If we lose the case, the public loses. So we don't have anything to lose in a personal manner. So that's how we look at a social activity or a fight in these corruption cases or in the public domain.
Right. But I was looking at the arguments made by Mr. K.G. Raghavan, who's the lawyer for Mr. Nalin Katil, and he said that putting money in electoral bonds can never be extortion. Now, what did the judge react, and how did he react when Mr. K.G. Raghavan said this?
Well, it is not fair enough for me as a petitioner, as a respondent, to be speaking about the reaction of the honorable judge. It's up to him, and it is right there in the website of the YouTube in the High Court, so anybody can see the reactions there. But all I can say from our end, as a respondent, is that our advocate Prashantji has put in some very valid legal points, since he is a very experienced advocate, senior advocate. And we are even as with my whatever little legal knowledge that I have, I'm pretty sure that this angle of what do you call the locus standi of a complainant, in that case, we are quite in the right path, and I think we can circumvent that bridge when in the future also.
But Adarsh, I want to know a little more about the complaints which you had filed, because on Saturday when I was reading the story, I also saw reports which said that you had filed about 14 or 15 complaints, but only one of them got noticed, and that's how the special court in Bangalore, the ACMM court, directed for the FIR to be registered by the Tilak Nagar police station. So does that mean that now you've forgotten the other complaints, or will you pursue them as well? Or your focus now entirely is on this Tilak Nagar police station complaint?
Well, it was a deliberate strategy from our organization, because we had collaborated with not just with another three more organizations, where we had culled out so many other cases of extortion through electoral bonds. And we said that each and every cause of action, as we speak in the legal terms, every cause of action or every incident of extortion requires a separate investigation, because each and every facts are different. Like you have in some cases IT officials involved, in some cases ED officials involved, or in some cases GST directorate is involved. So we cannot club everything into one this one case and mammoth case, and it will be impossible for anybody, for any investigative agency, to investigate into so many cases in this one. It will take years and years. So what we did was, once we culled out all the information, we said that we will file the complaints before the police station, and if they file the FIR, well and good. If they are not going to do it, then we are going to the DCP, the next level, and we are going to file another 15 before the DCP. And if they file it again, well and good.
Adarsh, but the next question is that you got the case registered under IPC and not under the Prevention of Corruption Act. Now, was this also a strategy by you all?
Yeah, actually, it is a clear case of extortion. There is no doubt about that. Because what we have, there are other cases of corruption also. Like if you see specifically mega engineering, they got projects. And that was right before getting the project. They had paid the donation through the electoral bonds. So once you pay it, you get some project. So that is like a quid pro quo there. There is a clear quid pro quo there, which amounts to corruption. So we have not touched those cases at all, because that will be, as you said, corruption cases, and that has to fall in some a locus standi also, where we have to see the cases where exactly they happened, all those things. Whereas here in these cases, some of the many of the raids, what we are very sure was whether it happened in Karnataka for this one, like in Aurobindo Pharma, it happened in Karnataka also, and some other many other cases, like there are Bangalore-based companies. So we have looked into those things also. So we are quite we have studied quite a lot and made sure that extortion cases, extortion, the offense is made out in these cases. Whereas there are, as you said, there are corruption cases also, but we have not gone into this because it's a massive scam, and just one organization cannot be doing the entire thing. As you said, there are so many other organizations working on that, and we hope that they come out with so many other complaints also.
Stay ahead with our cutting edge news app. Instantly access the latest shorts in just 1 minute and breaking news in just 50 words. Download now for a smarter, faster news experience.